Good morning, everybody. Looks like we do have the Brian Walshe hearing up. This is from NBC 10 Boston, courtesy of them. So I'm glad that they are live streaming this. See if we can blow that up for everybody. There we go. So a lot of action in the Brian Walshe case recently. Some of you may know it's the evidentiary hearing involving the search warrants, the Google search, whether there was consent to search all of his Google searches. So these are significant issues in this case. And they involve all the same players in the Karen Reed case. We had Lieutenant Fanning there in the evidentiary hearing. We had Buchanan. And we'll see what this hearing is all about regarding that. My understanding is that this is an important hearing, and that's why I'd like to stream it and analyze it. So here we go. And this is as loud as I can make it. And I hope to get the audio worked out there. Nothing I can do from my end. Apologize. If you guys have another stream, let me know, but this is all I found. There we go.
Comfortable with that, so his counsel will vote.
Looks like they worked on the volume right there, so getting a little bit better.
So we're here today on, I guess, to handle two matters that are on my radar, and I'm happy to handle anything else that you want to bring to my attention. Of principal concern to me today is the defendant's motion to dismiss, and also a motion with regard to the, I'll call it the federal protective order. And I just want to address that specific to this case. I think that we were all on a call, we're all listening to the same hearing before Judge Rupp. I didn't feel the need to necessarily engage myself in those hearings and let it play out. As you know, I sort of put a temporary hold for a hearing last Friday, which I ultimately decided we didn't need to do because of the events as they progressed. We can talk about that as well today and how that particular issue impacts this case, which may be very different than some of the other cases that were involved in the prior hearing. But I'll hear on those two motions, and then again, anything else that you wish. So let me just tell you where I am with regard to my level of preparation so that you can respond accordingly. I have read all the days of the grand jury transcript. I have read, I'd probably say 75% of all the documents that were presented to the grand jury. And that 75% is directed towards the issues that I thought were important today. So for instance, I didn't spend any time looking at records that related to I read all relevant, what I thought relevant grand jury exhibits. I've obviously read your motions, so as a preliminary matter, that's where I start. It's defense's motion. I'll hear from the defense first.
So this is the motion to dismiss and also about the federal materials.
Thank you, Judge. First thing I want to address is this, the interpretation of Riley. We cite to Riley, and then the Commonwealth cites to Riley, and it appears that the Commonwealth relies on Riley and their interpretation of Riley to say, since we, in their opinion, met the sufficiency of evidence as to premeditation and specific intent, now we can also prosecute on extreme atrocity and cruelty. Let me just first address Riley. That's not what Riley says. What we made clear in our memorandum is that Riley stands for the simple proposition that they clarified the case. They basically said, just to be clear, the case was talking about the face of an indictment under 265.1. And they said, well, listen, now this case Riley presents a different matter. And so to be clear, you have to present sufficient evidence to the grand jury on first-degree murder. And they kind of left it at that. Then the opinion kind of wanders off and says something about, in footnote 8, that the Commonwealth tends to rely on, saying that if you present any theory of first-degree murder, you can then, it seems to be saying you can, at least that's what the Commonwealth says, you can then prosecute on any theory. That's not logical. If you just think about it for a moment, Jeff, that would defy well-standing law. Moran, Walshe now, Umberto H., Handwright, the cases we cite, and two of the cases that they cite, Moran and Walshe, that make it clear that elements of the crime at issue, the grand jury has to hear sufficient evidence to make out the elements of the crime that is going to be indicted. And what does that mean for this case? What it means is that you have to, if you want to prosecute Mr. Walshe on a theory of extreme atrocity and cruelty, you have to give the grand jury at least sufficient evidence, meaning the probable cause to arrest him, on what the elements of extreme atrocity and cruelty are. And what do those elements include? They include the three now Castillo factors, that the grand jury has to hear sufficient evidence of at least one. I would suggest at least one, if not all three of those factors. They heard nothing at all. And the Commonwealth, in their memorandum, does not even try to argue that they presented any evidence of those factors. And why is that? Why is it important to understand what Riley says and what Riley doesn't say? Because if you just think about it for one moment, if a grand jury only heard sufficient evidence of third-pronged malice, an intent to do an act that a reasonable person with the facts known to the defendant at the time would have believed would have resulted in a plain and strong likelihood of death. And let's just say, for this hypothetical, that the grand jury also heard sufficient evidence of premeditation, is it the Commonwealth's position that the indictment, whether it's issued with the language of 265.1, would allow a prosecution of premeditated murder? Of course it would. Because the only malice element that grand jury heard was third-pronged malice that does not apply to premeditated murder.
Is that fair recitation or evaluation of the evidence that was presented, that they only heard third-pronged malice?
No, I'm not representing that, Judge. I'm trying to just distinguish and make clear.
All right, so let me just ask you, Attorney General. It seems to me that this motion to dismiss is based on an argument of insufficient evidence. And the issue that you're raising now seems to me to be something that is relevant, perhaps, to a motion to limit it with regard to what the Commonwealth can produce at trial. But your task today is to convince me that there was insufficient evidence of premeditation, right?
Well, that's right, and so, insofar as you stated it, I understand my task is also to argue that they did not provide sufficient information to establish.
But you agree with me, sir, that if they provided sufficient evidence of premeditation, the first degree murder and malice, the first degree murder indictment stands.
The first degree murder insofar as it alleges premeditated murder.
Goes back to what I just said. Isn't this an issue that you're addressing with the court? An issue with regard to limitations on evidence if you're unsuccessful in this motion down the road?
If I understand the court, Judge, and I might not, so let me know if I'm not. But all I'm saying is, I think what is being confused here is the interpretation of how the statutory language of 265.1 encompasses all three theories of first degree murder. It encompasses second degree murder, and it encompasses manslaughter, unless it's otherwise limited by the grand jury in the language, and that's pretty clear law, at least since 2009. What I'm here for is to say that so much of that indictment that is the Commonwealth believes alleges first degree murder based on extreme atrocity and cruelty, it does not, because the grand jury did not hear sufficient evidence of first degree murder. The same with felony murder.
I understand the argument. I will take a closer look at it, Radner, maybe not for purposes, maybe for purposes of resolving this dispute, but certainly for purposes of future aspects of the case. But you need to convince me, I think, the Commonwealth, whether they would like to proceed on the theory of cruel and atrocious or not. It's clear that their fastball, so to speak, in this case, premeditation. So convince me that there's not enough in the grand jury transcripts. And not only in the transcript, what's before the grand jury is all of this, and this is only part of this, all of the exhibits that were presented to the grand jury is before them. And one of the things that I noticed when I was reading through your argument is you almost exclusively focus on the testimony that was provided to the grand jury. And I don't want to say you ignore the other stuff, but it's not discussed. And it is before the grand jury for them to consider. So convince me that there's not enough there.
Well, there's nothing in the grand jury exhibits that have any statement, any conduct that can be attributed to Mr. Walsh, that he planned a murder, that he planned to harm Mr. Walsh. Nothing at all. All of the conduct of the exhibits that are contained in the exhibits are conduct that occurred after something happened. If any, whatever was happened, after something happened.
What do you mean by that?
Because the clear reading of first, the searches, don't indicate that he's planning or anything, other than he's talking as the grand jury was testified to, asked by the prosecutors, how do you characterize those searches? Your searches about how to put it out. How do you put it out? There's not one search. There's not one example presentation, any statement, any plan, anything by Mr. Walsh about things you are harmed by anything.
I understand from this argument.
Yeah, put that right there.
With regard to premeditation, their argument would be from their opposition that it's reasonable for a jury to infer that credits the defendant's statement that on the left house at 6 6:30, 6:35 in the afternoon, in the morning, excuse me, that it would be reasonable for them to credit that the 6-year-old son saw his mother that morning in the early morning. It would be reasonable for them to infer then that those incriminating searches between 4:53 a.m. and 6:35 a.m. happened before she was murdered, and that's supported by a 3-hour break in the searches from 6:35 until 9:35 a.m. There is significant motive evidence that was presented to the grand jury, about $2.7 million in life insurance, about knowledge that Mr. Walshe, that his wife was having an affair probably as early as December 25th, 2022. And there was his motive evidence with regard to the conundrum of the federal prosecution and his pending sentence. That's all before the jury. As I understand their argument, it is that those searches that are done, and there's 8 of them done before 6:35 in the morning, are prior to. And even though it's reasonable to say that those searches relate to what you do once you have a dead body, that it's not inconsistent with the fact that he may not have yet killed her at the time that he did those searches. Those are the reasonable inferences they're saying that a grand jury could have found. Why isn't that within the bounds given the evidence that was before the grand jury?
First, the Commonwealth says, on the one hand, based on the statement of the defendant that and of the young child, that he saw his mother, and then they go on to say, but the defendant was coaching him. And then at the grand jury, they go through an enormous amount of effort to dispute whether the child actually saw her. They put on witnesses talking about everything from how well he understands English, the young child, what he does, what he doesn't understand, that he couldn't have created the searches. But they go on to try to dispute that what the child said is not accurate, and it's the result of coaching by the defendant. That's what the Commonwealth presented. We weren't there, but that's what they presented. Let me talk about the insurance. The court used the word motive. It's possible motive evidence, but motive evidence is not premeditation, and motive evidence is not malice. And there is nothing untoward about life insurance policies named in anybody's name, and there were still life insurance policies presented to the grand jury that still had Ms. Walshe as the beneficiary. So now we look at that quality of evidence. It may be some evidence of motive, but it is not evidence of premeditation. It is not evidence of malice, according to the case law. And there's nothing in these...
Well, but the evidence of malice that they're going to rely on that was before the grand jury is certainly contained in those searches.
If the searches happened before.
That's their theory.
That is their theory, but...
One of their theories, anyway.
But their evidence presented to the grand jury doesn't establish that, and it requires the grand jury to speculate and pile inference on inference and say, well, maybe it could have, I don't know what the grand jury was thinking.
All they have to believe is Mr. Walsh's own statement that she left at 6:30, right? And those searches.
But I think what the court is saying is the grand jury heard sufficient evidence to establish that somehow that contrary to what the Commonwealth presented to the evidence, the grand jury can still ignore what the Commonwealth presented, and that is they disputed that the child saw his mother at 6:30 in the morning. So you can't just throw, forgive me, but You can't just throw things against the wall and see what sticks, then walk away and say the grand jury heard sufficient evidence. And because that is the probable cause to arresting.
They don't need Thomas Walsh's, they don't need the minor's statement to establish probable cause. They can go at it alone with Mr. Walsh's statement, she left at 6:30, and the fact that those 6 searches are done before then. Isn't that sufficient? Counsel, we're talking about probable cause.
Judge, but what?
I'm not talking about proof beyond a reasonable doubt.
No, I understand that. I'm talking about probable cause to arrest and reasonable inferences on trustworthy evidence. What did the Commonwealth do in front of the grand jury? They tried to demonstrate that Mr. Walsh lied about Anna Walsh leaving at 6:30. The Commonwealth spent more than a day putting on evidence that she didn't leave at 6:30. She never left. So what he said was a lie. And that's the quality of the evidence that was presented to the grand jury. So if now the government wants to stand up and say, well, we want to have it both ways. We called him a liar in front of the grand jury. And we don't want the grand jury to believe that she left at 6:30, but we're going to rely on that very same evidence to construct this argument that, as they say on, I forget what page it is, I have it, but they say that in a cryptic one sentence, maybe those searches happened before. And that's all they do.
All right, what's the argument? Let's change the playing field and say the argument is that, because they could pursue alternate theories, that she was murdered prior to the searches. So your argument with regard to lack of any probable cause before the jury is stronger, right?
I think so, yes.
All right. Anything else you want to ask me, that you want to tell me?
About premeditation?
Yes.
We shouldn't discard the fact that premeditation requires, I understand there's a lot to do about the time element, and I'm not even going to recite all that case law, but the case law also makes clear, and I cited to the model instructions for homicide on premeditation, that it's not just that someone says, okay, I'm going to kill somebody. There has to be cool reflection, there has to be a thought, and then it has to be followed by action. They have no evidence of that. If the evidence is that now they want to construct an alternative argument that, okay, even though we wanted to convince the jury that Mr. Walsh was lying about 6:30, Anna Walsh leaving at 6:30, and even though we want to try to convince the grand jury that he coached his son and his son never saw Anna Walsh, we will nonetheless use that as sufficient evidence to get the indictment based on premeditation. That is not due process. And that's exactly what they did at the grand jury. They disputed the evidence. They did not endorse it when it came to what time she left and if the son ever in fact saw her. And now they want to use it. If they try to use it, they want to use it to say, therefore, the searches happened before the death. And the grand jury is entitled to do that. When in fact, the only evidence they presented to the grand jury was, you can't believe she left at 6:30, and you can't believe that the son saw her.
So the two of you are going in different directions on the significance of the destruction of evidence. That is the Commonwealth cites to, and I will candidly acknowledge I haven't looked at the different cases that you cited. I certainly will before I make any decision on this case. But the Commonwealth cites to the defense's argument that is sort of that destruction of, under the law, the destruction of evidence is not relevant to the issue of premeditation. And the Commonwealth cites me to, I'm going to butcher the last of this, but I'll spell it so I don't butcher it, Dageneais, Dene, a 2002 case for the proposition that evidence of destruction of evidence is highly probative on the issue of premeditation.
Well, I think I'm sorry, I don't want to interrupt.
Go ahead. That was the end of it.
Okay. And I too don't want to butcher the case
You
name.
can call it just D.
We'll call it D. Look, all that case said was, and the Commonwealth uses it in their memo, all it says is there's no blanket rule.
Prohibition against it.
That's right. But then you have to look at all the other cases that talk about that, and all the other cases, Blakey and all the other cases that we cite, say, well, it doesn't have any bearing, destruction of evidence doesn't have any bearing on premeditation if it happened before the blow. That's the phrase used in Blakey, before the blow was struck. That is bedrock case law. That's what they're talking about. So now, getting to your point, Judge, what is the case that they cite and is Nadworny? And I think that Nadworny talks about, consciousness of guilt evidence that may be used, may also be used to demonstrate, let's say, intent. And it goes hand in hand because there's a difference between the analysis of premeditation and intent. But what Nadworny case way back in the 70s says is that on those facts, you could consider the condition of the body found in the trunk of the defendant's car that had been in the trunk for 4 months and show decomposition, show that it was specifically wrapped up like a funeral director may do it because his father worked at a funeral director. And they go on to elicit all those facts of how that type of thinking can be impugned to that defendant. You don't have anything like that here in this case. And so the grand jury didn't hear anything of the sort like that. And Blakey says, as well as any number of cases, say that consciousness of guilt should not be used to try to prove malice or premeditation if you can't demonstrate that the so-called consciousness of guilt evidence, and I will say for purposes of this motion, it's probably likely that at trial, those searches would be considered consciousness of guilt if the Commonwealth can demonstrate sufficiently prior to introducing them that they were in fact created by Mr. Walsh and no other person, that they could be considered consciousness of guilt, but that's the limitation. And the case law that they cite and that we cite go on and talk about the errors that are asserted in appellate review where a defendant argues that you used consciousness of guilt to influence the jury on intent and premeditation. And what the analysis shows in many of those cases is, well, where the jury got a complete instruction on consciousness of guilt and premeditation and all the variations of malice, and many times these decisions are made by a substantial miscarriage of justice. But the point is, they're saying in those cases, we think the jury understood that you can't use that evidence other than consciousness of guilt. So in this case, you might have consciousness of guilt evidence, but that is not evidence of premeditation on these facts. You might have consciousness of guilt evidence, but it's not evidence of intent, and it's not evidence that establishes any of the 3 prongs of malice. And that's what we argue throughout our brief. I think I heard Your Honor refer to affair, the knowledge of the affair. Let me just talk about that for just a moment. And then I have to circle back and not repeat what I said, but I want to talk about inferences and how they apply to the arguments that the Commonwealth makes in their memorandum. First, I know the government wants, and they've said it to the public, but they're just wrong. Mr. Walsh did not know about an affair, period. What AK, and I'll just use the initials that I did in the memo, what AK told the grand jury was that Anna Walsh had talked about telling Mr. Walsh she had a crush on someone. There was no testimony by AK that Anna Walsh discussed with her that Mr. Walsh knew about the affair. It was ongoing.
I don't think that's correct, Counsel.
Okay.
Let me tell you what I have in mind from reading. I just Just need to find the right piece of paper. But I will. AK testified that the defendant told Anna that his mother had told him that Anna was going to leave him for a guy in DC and take the kids, and that he believed that. That was her testimony.
I'm trying to think of that specific, I recall that specific testimony, but I don't think, I thought it said that, well,
59 to 60 of the transcript.
all right, can you pull that up?
Your Honor, do you have a date from that grand jury?
March 8th, 2023.
Thank you.
The defendant told the police in his January 4th interview that he had access to Anna's iMessenger on his phone and some access to her Instagram. Those are the two ways that Anna communicated with WF for his testimony. Also before the grand jury was that he, the defendant, searched WF's name 6 times on December 25th, 2022. That there were 20-something, 21, 25 searches between the 26th and January 1st on his Instagram account. They don't know where they were, too. Also before them were the messages between WF and Anna, which leave little doubt that there was an affair going on.
When if I may inquire,
So
Judge.
I've got to assess the evidence that was before the grand jury in its entirety. And that was the entirety of the evidence that was before them with regard to whether there was an affair going on and whether he knew about it, right?
Well, that's not the entirety. I'm sorry, Judge. I don't.
Well, that's some of it.
That's some of it. It's not the entirety, though, because the entirety also includes the testimony of the other testimony of AK and the other testimony of WF. And that testimony from WF was specific that him and WF and Anna were talking about their affair and that she wanted to tell Mr. Walshe about it, that she would, quote, be devastated if he learned about it. And then there's this conversation about his mother hiring the psychic and that's where that came from. Hiring a psychic that told her, the mother, that Anna Walshe may leave the defendant for someone in DC. And then WF is asked specifically by the government, was there any conversation about Mr. Walshe knowing, I'm going to paraphrase, knowing about the affair? No. Was there any conversation about whether she had told him about the affair? She wanted to tell him about the affair at some
Doesn't
point.
that evidence go to the issue of whether or not Anna knew that Brian knew about the affair, not whether Brian knew about the affair?
Well, when the court recites the fact that if we assume for purposes of this motion that Mr. Walshe is the one that reached out and tried to search for WF, how does that show, how does that demonstrate reasonable and trustworthy and reliable facts, articulable facts, that he knew about, quote, an affair, as opposed to the simple truth that was presented to the grand jury that she had a crush on.
Well, let's put aside the searches on the
Okay.
searches on the December 25th. Put aside the 21 other searches between those dates. And just focus on his admission to the police on the 4th, of his access to her Instagram and to her iMessenger, and WF's exhibits of the messages between Anna and himself. As I said, there's little doubt based on what's in there. You know what's in there, that there was an affair going on, right?
And you're referencing the messaging between Anna and WF.
Which,
Right.
correct, which the defendant told the police on the 4th of January that he had access to that during his interview.
He may
That
have,
was before the grand jury too.
he may have told, he in fact told the police that, yes, he had access to it. He never told the police that he read those text messages. He saw those text messages.
Isn't that a reasonable inference?
Why would it be? Why would it be a reasonable inference that jumps from the fact that someone may in fact be able to access messaging, but there's no, that he has access to it, but that in fact he did? Why is that?
I don't think that was his, I don't think that's his language on 1-4, but that he had access to it. I'll go back and listen to it again, but my memory of it was that they were coming up on his phone.
Okay.
But I'll go back and refresh that. But what did you want to, so this idea, this notion that, that there's no evidence supporting the fact that he knew of the affair, just doesn't seem to me to be a fair assessment of the evidence that was before the grand jury.
And what we're arguing, Judge, that it can only be a fair assessment based on reasonable and articulable facts of trustworthy information. There is no trustworthy information. There's no information at all that Mr. Walsh read Anna Walsh's messaging between herself and WF.
Does somebody have the January 4th interview, page 30, lines 8 to 22? I have it here, I just don't know what exactly it is. Oh, maybe I do. Anyway, I'll go back and look at it. That's the area where, that is the location where he discusses in his interview on January 4th, his access. You may be right, it's access and not that he actually looked at it.
And I'll take a look and see if I'm wrong. too.
All right.
Could I just go back to pages 60 and 61 and
Yes,
that
I'm
issue?
right now.
So I thought the court had recited in saying that there was testimony that Brian believed.
Anna believed, Brian believed. So
Where-
I'm on 60, line 11. Diana was convinced that she went to a psychic, and that due to that, she was convinced that Anna was going to leave Brian for some guy in DC and take the kids, and that she believed Brian believed that.
Well, but that, maybe I misheard the court. I thought you said that there was direct testimony that Brian had represented that or there was a statement attributed to Brian Walsh.
No.
That okay.
He consistently, throughout his interviews, as I know them with the police, averred that he wasn't having an affair, and he didn't believe she was either.
Okay, so turning back to that now, Judge, line 11 at page 60. Anna can believe what she wants to believe. There is no factual basis presented to the grand jury that Brian Walshe did, in fact, believe that. In fact, the evidence presented
Believe what?
that she was having an affair. In fact, there's testimony at the grand jury that this psychic investigation was revealed by Brian to Anna Walshe. So how is it then that when people are sharing information and nothing happens at that time, nothing untoward at all happens at that time, that the government can then move on and pile another inference on top of that inference and say, therefore, Brian Walshe believed there was an affair, and therefore Brian Walshe acted on that belief, and therefore there's evidence of premeditation as opposed to motive or whatever. But how can a grand jury be permitted to pile inference on inference when that's what the government is at, if in fact that's what the government intends? That's what occurred. There is no trustworthy, reliable information that Brian Walshe believed or knew about an affair. And when you consider the testimony of WF at the grand jury, and the testimony in conjunction with AK, did she ever say he was jealous?
Counsel, let's circle back to those December 25th, 2022, the 6 searches with regard to William Fasto on that day.
So
there are 6 searches that are done on a device that's attributed to Mr. Walshe for Mr. Fasto's name on December 25th.
yes.
I think it's just randomly searching the guy's name on December 25th, the day that his wife is supposed to be coming home and missed her flight.
Well, he's trying to find out where she is because she's late, and she had to leave on the 25th, and she misses the flight, and she has to drive up.
And she thinks of William Fasto, or he thinks of William Fasto.
Well, he's also reaching out to others, I believe.
He didn't, as far as I know, the only information before the court from the materials that were in the grand jury is he searches William Fasto's name 6 times that day.
Okay, but William, she's already, if you believe what was presented to the grand jury, and that's the constraint we're under right now.
Sure.
She, according to AK, she told Mr. Walshe she had a crush on WF. So why wouldn't he, if your spouse says, I have a crush on this person, the other spouse is not allowed just to say, I want to learn about what that other person is.
When does, and this is up for grabs for either side, I have a question with regard to the evidence that was before the grand jury. I'm just going to find that. So much paper.
Yeah, again, this all comes down to whether there's sufficient evidence on the premeditation
You
part.
can't be an environmentalist, I'm afraid, and be a lawyer.
Not a lawyer that's this old anyway.
So,
One of the exhibits to Mr. Dozier's grand jury is a series of voicemails left by left by Diana. And I've listened to those files. My question for the more technically enabled people is, was it before the grand jury that file number 046, or any of the files that Mr. Dozier provided, time-stamped in any way?
Hmm.
Does anyone know that from your review of the evidence?
off the top of my head standing here.
All right, so the Commonwealth, I know there's a lot of you over there, but if somebody can answer that question when you get up to argue, if you can, I'd appreciate an answer to that.
But talking about, and you're talking about the investigator. When you, right.
Yes,
Okay.
and it was something you just said triggered that memory of sort of a open question in my mind was whether or not the grand jurors had before them, other than by context of what's being said in those messages, the timestamp for the days those messages were left.
And we can get the answer to that question, but the testimony of Mr. Dozier under oath was that there was no testimony that he got in. That's the other interesting thing. He never got a name.
Well, he never gave the name. He had a name. They had a person of interest. It was WF, but he never provided that name to them. That was something that's how I recall his testimony.
And what I was about to say was he never testified, and he was asked, or I guess asked in substance. No one like Brian Walshe gave him a name. And in fact, the government kept asking that witness, when did you ever talk to Brian Walshe? Yes, we did have some conversations. When did that occur? If my memory, I'm paraphrasing, if my memory serves me, it was sometime after January 1st. January 1st. So I think that's another piece of trustworthy and reliable information that someone could make an inference that at some point Mr. Walshe became aware of an investigation that his mother instigated, but there was no evidence that that investigation was informed by Mr. Walshe. And Mr. Walshe didn't have a reason to get on the phone and say, hey, apparently, to check out this WF guy. So that's why we say in our memo that when the government begins to spin out what it believes are reasonable inferences, they are not grounded in articulable and trustworthy and reliable facts. They are the ruminations of the Commonwealth trying to justify that what they presented to the grand jury is sufficient in making out the elements of the charge, even though, as I return briefly, they don't even attempt to make out the elements of extreme atrocity and cruelty when it comes to what was presented to the grand jury. Another final example of this, and I know the court didn't reference it a moment ago, but it's this articulated argument by the government that somehow, and they go on for almost a full page talking about the facade that Mr. Walshe created by making it look like to everybody that it was just a happy family, and that was his plan to present to GM this presentation that it was just a happy family. You know, Judge, what the grand jury, and that's the government's inference. Okay, what's the articulable and reasonable facts, trustworthy facts that establish that? Nothing at all. It's an inference that is created out of whole cloth, and it's used by the Commonwealth in their memo to suggest, see, that was his planning stage. That's what he was planning. Who invited GM?
Anna did.
Anna
On
did.
December 29th during the phone call.
And here's this long visit of hours where there's nothing but happiness and cooking and eating and a little bit of drinking champagne, and then at 1:30 he leaves. We recite all of that evidence because it is the trustworthy and reliable evidence that the grand jury heard and contradicts not the other evidence that they heard, it contradicts the inferences that the government is trying to make. Did it get across the finish line here on the grand jury presentment? And
Well, I credit what you're saying, that this argument that he somehow in some planning phase called Mr. Mutlu invited him over for, I probably mispronounced that as well, but invited him over for dinner is contradicted by the evidence that Jim himself presented, and which he's clearly said he was invited by Anna on the 29th. It's contradicted by the text messages between Anna and Mr. Fasto, in which she discusses inviting him over. So I credit that the evidence wasn't that was a planning thing as far as the evidence that I can see before the grand jury. But also, it's clear that there was sufficient evidence before the grand jury that this marriage was in distress over the issues relating to his then pending federal sentence and the implications of that on their life and where the children lived. It was clear that AK was seeing something different than she had ever seen before in her friend, in her demeanor. She mentions that in her, which a reasonable inference could be based on the context of that, which was she was talking about her marriage and the failings of her marriage, that their marriage was under stress. So while I credit you that this notion that he planned this by ordering or by inviting Jem over, there doesn't seem to be any evidence before the grand jury that I can see. They'll argue otherwise, perhaps.
And let me respond to some of that, though, Judge, some of the themes of what you just said. Once again, I'm going to very quickly refer to AK's testimony. Yes, friends with Anna Walshe, recited conversations with Anna Walshe, was asked specifically, did she ever talk about divorce? No. What did she talk about? She talked about the frustration of not having the 3 kids in DC and the time it was taking. And who was Anna Walshe angry with? She was upset with Brian, but she was angry at his lawyer because she thought the lawyer was the one setting up this idea that the 3 children had to stay in Cohasset. That wasn't Brian's doing. The government tries to argue that, but that's not what the grand jury heard. Also, AK testifies initially.
But what the grand jury heard is she was angry with him because she had learned that it was not the FBI, but rather Brian himself that was delaying his sentence. Delaying the trial or the resolution of that case.
And she goes on to, I understand, she goes on to testify that Anna Walshe then was talking about Mr. Walshe, Brian, had to take responsibility and that they needed to work through this. Right. And that's exactly what they were doing. To suggest that stressors, serious stressors, that have been going on for some time, somehow transform into motive to kill, malice, or premeditation, is once again an inference that is not supported. It is, somebody can dream up the inference like the government is doing here, but it doesn't rest on the facts, and it doesn't rest on the entirety of the testimony of of AK. The same thing with the WF testimony. You know, if what the grand jury heard was, yes, there was conversations, but there was never the only conversation that he recalled where divorce was mentioned was in terms of, quote, protecting assets. And I will just, that's it. That's all he recalled. And when the assets may have been the life insurance. It might have been the value of the condominium, $1.3 million. It might have been the other properties they owned. They were renting the Cohasset property, but maybe the other properties. But here is WF being asked a myriad of questions about, well, didn't she talk about this? Didn't she talk about that? No. She, quote, I'm not quoting, paraphrasing. WF said that what Anna Walshe described Brian was basically this wonderful man. That doesn't sound like, and it can't be used to now construct some argument that whatever stressors were going on in the family then can be used to establish premeditation or malice in any of its forms. It is, as we say, it is piling inference on inference, and doing so is violation of due process in Article 12 because the grand jury wasn't presented that type of evidence. It is the inferences that are being constructed by the Commonwealth that aren't grounded in articulable facts, plain and simple. The other thing is about the money. They'd already started paying the money back. This idea constructed out of whole cloth that somehow one of his motives was to murder his wife so he gets.
Uh-oh. Let's go, NBC Boston. You got this. Well, we are hearing some bits and pieces from the grand jury, what happened there. Whether Brian Walshe actually knew about the affair. Now, he had access to a lot of the text messages, apparently, that Anna Walshe was texting her lover, perhaps. But does that mean that he actually saw them? That's the argument that the defense is making anyway. Well, while we are waiting for NBC Boston to figure this out, and I'm not sure if the other streams are having the same thing, but I will check the other channels. I don't think Court TV is having this. I don't know why. Law and Crime Network, I don't see that they have it. But I'll keep looking now that we're on a little pause. I'm sure NBC Boston will figure it out, but in the meantime, I'll start looking around. Something tells me that this picture is probably better than what you're getting on Zoom. But I'm going to keep looking. We'll find it. There we go.
His statements that some restitution was
Yes.
paid.
And they did not hear any evidence that there was some conflict about, or some argument about the amount of money that had to be paid back. There's nothing like that presented to the grand jury. There were the stresses revolved around primarily the three children in the DC. And once again, AK testified about the plans that both Brian and Anna Walshe were trying to make to move the three kids up to DC. So what you have is testimony of stresses in a family grounded in what we'd all believe would be true. Three young children living in one place, mother living in another, and they're trying to work this out, and it's taking longer than expected. How does that become a reasonable, articulable, and trustworthy fact to build a premise that that stress led to premeditated murder or malice in any of its forms? It's pure conjecture, it's speculation, and it can't be the basis for this indictment. I don't want to keep going on here. would like just to make clear something here before I sit down. And you can shut me down, Judge, I know you will if you want to, but it is this Riley thing. And let me just say briefly, I would be
I
happy.
won't shut you down because I'm still not convinced that it's relevant to the decision I need to make on this motion. But
Okay.
it's certainly going to be relevant later, so that the earlier I get educated, the better.
So let me try to make, the argument that it is relevant.
Okay.
Because we do argue it. What we're saying basically is that the grand jury has to hear the elements of the offenses that are encapsulated in 265.1 statutory language. It's not, there's two separate bodies of law. 265.1, that covers all the theories, but that is a procedural issue. It's a little substantive, but it's procedural. Over here, we have all the case law, Moran, Walshe, and I believe, the way I interpret Riley, to say this: you have to present the elements. And for some reason, the way the justice wrote that opinion in Riley was, we want to clarify what we left open in DePace. He doesn't talk about Moran or anything. And what I think he's clarifying is, let's just be clear. In DePace, we talked about 265.1 because the challenge was on the face of the indictment. In Riley, we're talking about something else. We're talking about what the grand jury heard. And so under Moran, if the grand jury does not hear sufficient evidence of the elements of a particular theory of murder,
Then
the indictment, as we're asking, that so much of the indictment that can be read to include, in this case, extreme atrocity, and they didn't argue felony murder, so I'm not going to waste the court's time on that, but extreme atrocity, you can't try him on extreme atrocity because the indictment doesn't include it.
See, we're ending at the same place. To me, you're seeking to limit the Commonwealth with regard to the theories it may pursue at trial based on a failing in your perceived failing of proof in the grand jury. It seems to me that's not a dismissal of the indictment for first-degree murder. It's a motion in limine to say that the Commonwealth can't have that evidence at trial. Even if I credited your view, your world view, with regard to that case law, that alone wouldn't result in the dismissal of the indictment because of the evidence, if I credited it, of premeditation, right? That's why I see this slightly differently than you do.
Well, and I would agree with you, Judge. If you found sufficient evidence to the grand jury of premeditation and the type of malice that only applies to premeditated murder, if you find that, I agree they can. So much of the indictment that charges first-degree premeditated murder stands. But it's due process that requires this court to consider whether that indictment that was issued under the language of 265.1 encompasses extreme atrocity and cruelty, and for that matter, felony murder. And why? Because we have to be able to prepare our defense, and we have to know what the Commonwealth is going to charge, because that's the other part of this due process argument. We have to be prepared to challenge the extreme proof of extreme atrocity and cruelty, and they can't present it because the grand jury didn't hear it.
If my ruling, it ends up that the murder charge isn't dismissed, you have plenty of time. You don't have to wait on your motions in limine. You will have plenty of time to brief and address that issue between now and October. I mean, it's plain to anybody in this courtroom that knows the evidence in this case that whatever the Commonwealth's evidence is with regard to cruel and atrocious behavior certainly isn't their lead argument. It's not great.
Well,
I mean, it'll be strict. Even if I allowed it, frankly, this is where I go off script, and it's never good. Even if I allowed your motion or I denied your motion and said, oh no, they can go forward on both theories. As a strategic matter, they got to start thinking, are we shooting ourselves in the foot by doing so? Because from what I've seen, it's pretty thin.
I appreciate that comment, Judge. I understand you're not making a ruling, but I appreciate the comment, but I'm not going to,
But I get it. You have to get ready for trial in both theories.
and I'm going to infuriate Assistant District Attorney Cusick when I say this. I'm going to stop beating this dead horse. You and I, and Attorney Porges on behalf of Walsh, I don't think I'm making myself clear about the differences between what you're suggesting, a motion in limine to kick out a theory of first-degree murder, and what we're asking for the court to do.
You're asking me, I know what you're saying. You're asking me to dismiss it in so much as it charges cruel and atrocious.
Yes.
I understand what you're asking for. I'm not even sure, well, I'll look at your cases. I'm not even sure I've seen that ever done. It's an interesting concept. And I'll give some more thought to that if I get there. Maybe the Commonwealth will make our job easier.
It looks like they've made our job easier for felony murder. They didn't even brief it.
Right, well, we gotta start, October, TikTok, it's coming. So figure out what your theories are gonna be, and let's argue about the things that really matter, right?
Well, these really matter to us.
I
understand.
And I don't take any of this lightly. And when I say, let's talk about the things that matter, if it is the case that the Commonwealth's not gonna really pursue cruel and atrocious, then we're just wasting our time, right?
May I have a brief moment to ask a question?
Certainly.
Okay, so once this is done, I'll try to explain everything that's going on as much as I can glean from it, because we're really flying blind here.
And by the way, in fairness to both sides, I only know what I know. That is, I know all the stuff that I've read. I know everything that went to the grand jury. That was March 2023. What I don't know is all the stuff that's happened since March of 2023, and whether that has any bearing on the Commonwealth's ability to pursue a cruel and atrocious. I don't know. I only know what I know.
Your Honor, I'm going to sit down after I say this final sentence. That makes my argument. If they develop evidence post-grand jury of extreme atrocity and cruelty, they can't just decide, oh, now we have evidence of it, we can try them on that. They have to go to the grand jury and get an indictment. And I think that encapsulates what we're talking about here.
I understand the argument.
Okay. Thank you, Judge.
Thank you.
All right, who from the Commonwealth is going to argue this? Okay. Stand right up. Come right up.
Good morning, Your Honor.
Good morning.
Your Honor, the Commonwealth disagrees with Mr. Tipton's interpretation of the Riley case. Obviously, the court has it and will interpret it as the court deems appropriate. But I would suggest here that the court should not eliminate any theory of first-degree murder, because here the grand jury did have probable cause to find that the defendant committed a premeditated murder with the intent to kill. A few housekeeping matters. The Commonwealth agreed. We're not saying that we thought Mr. Walsh, or there was evidence before the grand jury that Mr. Walsh invited the New Year's Eve guest. That was Anna who invited him. The Commonwealth's argument is, with the guest being there, Mr. Walsh used the guest's presence to create a facade of a jovial, happy couple having a New Year's Eve celebration. And I suggest that that is also borne out by the fact that when Mr. Walsh eventually got in touch with the New Year's Eve guest, I think it was on January 4th, he was asked by the New Year's Eve guest, GM, well, did you argue? And Mr. Walsh's response was, you saw us. Did it look like we argued? So I would suggest that that certainly supports that dinner was used as a charade. Your Honor, the defendant had serious financial, legal, and marital problems in December of 2022. There was ample evidence that he was aware of Anna Walsh's relationship with a man in D.C. He's certainly doing those searches on Christmas Day. That's the day Anna had said she had to work. Mr. Walsh said that in one of the interviews with the police, that she wasn't home on Christmas Eve because she had to work. And there was Certainly, she did show up late. The flight had been canceled. She did drive up, and that's the night he begins searching those WF's name online. Then later on December 27th, he's doing a search about divorce and states to get divorced in, and the results of that search shows that Massachusetts is not a favorable state for divorce. And then the mother hires the private investigator in D.C. Now, the mother says she got the name from Mr. Walsh, that he told her not to do it, but I would suggest here he gives her the name of a private investigator. She hires the private investigator to investigate whether Anna is engaged in activities that are not appropriate for a married woman. And I certainly understand the court's question about the timing of those voicemails. I don't know off the top of my head the voicemails from the mother to the investigator firm, but we will look into that and see if there is anything
The
in
one
it.
that I'm most interested in is, well, I'm interested in whether there's a timestamp on any of them, but the one that I'm most interested in is, file 046. And in that message, she indicates, my son says, could you please check WF? Because during that period, he was in Idaho and he just wants to see how often they saw each other. That's the one that I want to know, that whether the evidence was before the grand jury as to what the time frame of that was.
Certainly, Your Honor, we will re-examine the exhibits and we'll let the court know, and we'll let counsel know, obviously, what we decipher, whether the timestamp is indeed in front of them or whether it was not. Your Honor, here, the grand jury also had information from the testimony of AK about her conversation with Anna on December 29th, I believe. They went out to dinner and she describes Anna as just being beside herself. Anna described a huge fight with the defendant over Christmas, had given him an ultimatum about the children coming to DC to live with her. She had found out that the defendant, and she does mention the lawyer also, but essentially that the defendant had engineered the children remaining in Cohasset with him because it was perceived that that would help him avoid an incarcerated sentence on his federal case. Certainly there's discussion of that during the interview with the one where the lawyer was present at, and he makes a remark about which one could infer means essentially, well, if Anna's not around, that's off the table of me going to jail. But certainly recent news to the defendant and to Anna as related through various conversations that suddenly the topic of him going to jail had arisen, and that according to AK, Anna had said he should just do whatever is necessary to resolve this, even if it involves an incarcerated sentence. So I suggest that is another, we could characterize it as a stressor, but it's also another reason why if Anna's not around, if Anna is deceased or disappeared, the defendant would suddenly be a single parent, would have the children's sole caretaking for these 3 small children. He would potentially avoid that committed sentence, which he was very motivated, one could infer from the materials before the grand jury and in avoiding. He would inherit millions of dollars in life insurance proceeds from Anna. Again, those searches also include some searches for luxury items. One could infer that he's planning to how he might spend those proceeds. And he would also...
But those searches, I don't think that rings true, because those searches with regard to in terms of premeditation anyway, the searches with regard to the watch are later.
I agree with that, Your Honor. I just suggest that...
So how does that relate to premeditation?
Your Honor, I suggest it relates to the concept of having money, which was certainly a stressor, that the defendant needed money to pay that restitution. I know at some point, I believe it was in the interview with the lawyer, forgive me if I'm mistaken, but I think it was he owed $450,000 in federal restitution. And I suggest here, the fact that he is looking at luxury goods suggests that this is, again, expecting to inherit money. Some of the searches are for cleaning up crime scenes. Specifically, I suggest that shows that the defendant's awareness that this was indeed a crime and not some sort of accidental person dying in a home. Your Honor, I suggest also that the defendant's behavior before that time, approximately 6:30 in the morning on January 1st, his behavior before that time when he says Anna left the house shows that he was planning and premeditating and had the intent to kill her. She arrived at the home on December 30th from DC. She was not scheduled to go back until January 3rd. So certainly there's a block of time where no one at her work would be looking for her. He planned to appear happy and jovial with the New Year's Eve guest. And again, when he spoke to the guest next, and the guest said, "Were you arguing?" "No, you saw us. Did it look like we were arguing?" He also told the guest that his phone was misplaced. I suggest that that was also part of the planning, creating a window of time when he didn't have the phone, that it would be an explanation as to why not responding to any text messages. Certainly, how do we know this was planned? Forensic exam shows that that phone was actually in motion, being unlocked and plugged into a power source when it was alleged to have been missing. So I would suggest that's another thing that would go towards planning. And the defendant, planned for
The fact that he shut off his phone, or he put his phone, the phone that's missing, let's even make the most adverse inference to the defendant. That all happens after the Commonwealth believes that he's killed Anna, right?
Your Honor, he tells the
So
New
this
Year.
rearward-looking sort of concept of premeditation is a little bit difficult for me to
Your Honor, there's testimony
appreciate.
from the guest on December 31st, before Anna had been killed, that the defendant said his phone was mislaid.
All right, you're right.
So certainly the phone disappeared or was mislaid or whatever happened to the phone, but the defendant represented that his phone was mislaid on December 31st when the New Year's Eve guest was there with Anna. And the defendant also, there was a nanny coming that afternoon. She was scheduled to come about 2 o'clock on the 1st. Anna had told a woman in a nail salon that she and her husband, the defendant, were going out to a adults-only dinner in Marblehead. And certainly I'd suggest that there's no other evidence of that other than that statement. One could infer that the defendant told her that they had plans to go to this party in Marblehead, and that the nanny was going to be there. This would give the defendant, again, a window of time to take action to deal with the disposal of the body of Anna Walshe. Certainly from WF's testimony, it's clear Anna had no plans to tell the defendant about their relationship over the Christmas holiday. She said that he would be devastated, and she also said she did not know what he was capable of. And one can infer that the defendant certainly was seeing those text messages, whether he looked at the phone itself. He made some statements in the police interview claiming that Anna had put the phone upstairs based on a message from someone named Abdullah that had caused some controversy. Certainly the GM, the guest, sort of contradicts that, saying she was using the phone throughout. And other people, AK was receiving text messages from her, and she was texting with WF. Certainly it's a fair inference that the defendant saw those text messages and perhaps realized the true extent of this relationship that they were having, where they were discussing long-term plans, 1, 5, and 10-year plans, and there's a reference to travel that they had taken together. That it's fair to say that the defendant, that might have been something he didn't know about, because based on what at WF's testimony. And also WF, Anna sent a photograph of the house guest herself and the eldest son to WF, and that was something, again, that Mr. Walshe told police about, that she had sent that to him. So I suggest that certainly there's a very fair inference.
Play that again to me, that last statement.
During one of the police interviews,
Yes?
the defendant says that Anna had taken many photographs during the evening and had sent one of them to WF. And that's in, I think it's the third interview, the second or the third interview, Your Honor. And certainly I can find a page site for that.
Thank you, I appreciate that.
And Your Honor, I'd also, cases I'd call the court's attention to are Nadworthy, which is in the Commonwealth's memorandum. It's 396 Mass 342, and Cardarelli, 433 Mass 427,
Can you give me the second one again, please?
433 Mass 427.
Yes?
And these cases indicate that, in some circumstances, evidence of a defendant's activities afterwards, after a murder is committed, can be used to infer motive and malice. And I would suggest here the defendant's activities of looking up how to clean up a crime scene, his activities of purchasing large quantities of cleaning supplies in various stores, and certainly going to different dumpsters and disposing of, one could infer, the victim's body in her possession, certainly is indicative, should be considered as consciousness of guilt, but also as evidence of intent and motive. So, Your Honor, the court has all of the materials that were presented to the grand jury, the exhibits, which are voluminous, and the transcripts and the memorandum from the Commonwealth. If the court doesn't have any other questions, I would rest on the pleadings. If Your Honor does have questions, I will get the answers to those questions the court does have to the court.
All right. I don't have any questions.
Well, the Commonwealth would ask the court to deny the motion in its entirety. Thank you.
Well, I do have a question. Attorney Tipton is suggesting that I have the power under the law to sort of slice the bread, slice the loaf of first-degree murder, such that I could dismiss the indictment in as much as it charges cruel and atrocious. And you haven't talked about that.
Your Honor, I disagree with Mr. Tipton. The Commonwealth does have, there's very few cases on this that the Commonwealth could find. There are 2 unpublished ones in the Commonwealth's memorandum that deal with dismissal of so much of an indictment as charges first degree. I'm not sure if they split it so much as to theories, but I would suggest looking at the Riley case, it's clear that if there is evidence to support first degree murder under any theory, then
survives.
It survives.
The indictment survives.
And the Commonwealth may proceed at trial under any theory. Again, it would, and they also
Subject
mentioned
to any limitations that might come as a result of the motion.
Again, and I believe that it might be in a footnote, but there's reference to subject to bills of particulars or turning over evidence or information like that. It's not vastly, it's not any different than other rules.
Do you want to discuss what evidence the Commonwealth believes was before this jury on the theory of cruel and atrocious?
Your Honor, I agree with the court's description of it as thin. I don't disagree with that. Again, I would suggest that at this juncture, the court should not cut any theory out of the indictment and should instead, again, I imagine this will be litigated prior to trial. But the Commonwealth, again, if the court finds that there was sufficient evidence of premeditation, this juncture is not the time to make any determination as to what the Commonwealth may or may not do with other theories.
All right. I appreciate the argument on both sides. Attorney Tipton, it's your motion, so you get the second bite of the apple.
It'll be small, but because I'm not going to repeat what I said, but ask the Commonwealth judge, if you will, give you one citation for a case that says a trial court does not have the power to limit what can be tried based on what's presented to the grand jury. Those 2 cases they talk about, there's actually more, but I think they're talking about Johnson and Rivera, which were 128 decisions. They don't have any reasoning or rationale to them. They don't explain it. What we do know is that there is a whole body of case law where the court examines what evidence was presented to the grand jury to determine for the appellate court's reasoning, that there was sufficient evidence in light of a motion and in light of a ruling by the judge of, that there was insufficient evidence, and so you can't try the person on a particular theory of murder. I can give you the citations of those cases if the court permits, but I don't think the government here, and they have two well-versed appellate attorneys with them, can give you one citation to a case that says, you, judge, don't have the power to do what we're asking you to do. And of course, what we're asking you to do is, we believe, is grounded in the law.
All right, well, I'll give you a couple of days here or there to bring me up to speed or give me any citations. Obviously, you don't have to file a pleading. Just need to memorialize it and emails to each other that the cases that you're bringing to my attention. If you prefer to file a pleading, that's fine too. And if you give me case law, I'll just note the emails and put them, I'll just have them scanned or something so that there's a record of it happening if you need that.
I will file a very short plea.
Whatever's easier for you. All right. So that matter's under advisement. Now, so let me say that I was happy to see you all on the Zoom with me last week because we were getting the same information, although I think you were on a Zoom that I was not on because I did not get on the Zoom with Judge Krupp round 2. And the reason I didn't do that, and I apologize, by the way, if you didn't get notice that the 3:15 hearing that I had preliminarily ruminated about got canceled. I don't know if you were on there. I think what happened, honestly, and I don't want to throw anybody under the bus, is that a couple of clerks in Middlesex, in Norfolk were out in the afternoon. And so it was a slip stitch between what was probably apparent to you that by virtue of what had happened on Friday, we didn't have an emergency situation, although some could argue otherwise, and did on Friday. I understand from listening to the FTR. But regardless, it seems to me that we have a slightly different situation than maybe we have a different situation than what presents in some of those other cases. And here's how I think it might be different. Maybe I've got it wrong. But let me just start the discussion in this way. It seems to me that ADA McLaughlin is one of the signatories on the agreement as a result of being on the Reed case. And it seems to me that she is on this case, was in the grand jury throughout the 11 or 12 days of the grand jury. So she's intimately familiar with what happened in the grand jury. And otherwise is intimately familiar with what this case is about because she's still on this case. And being in that unique role as being A, someone who can look at the materials, and B, is assigned to this case, it would seem to me that she would know whether or not there were any materials that were required under Rule 14 and the case law to be produced in this case. And that situation does not replicate itself in all of the, I don't know if it replicates itself in any of the other cases that people were involved with Judge Krupp last week. I don't care about those cases. I just care about your case, this case. So it would seem to me that with that pause, I understand that Judge Casper has put a 30-day pause on everything for people to assess the situation. And it seems to me that what needs to happen is that ADA McLaughlin, who has access to that information, needs to determine as an initial matter whether there is anything in those materials that would be required to be produced under Rule 14. And if there are, we'll deal with that. And if there aren't, then the Commonwealth needs to aver by, think of a bunch of different ways, affidavit or otherwise, that there aren't any. Now, the backdrop to this is, as we know, and I'm not going to get the exact language correct, but when we asked for a TUI request earlier in this case. We're not giving it to you, but by the way, there's nothing there. That's my paraphrase of it. But that doesn't relieve the Commonwealth of its obligation. So that's how I frame the issue in my mind right now for this case. And I guess I think it's the defendant's motion that brought us here and alerted me to the issue. I mean, the Commonwealth gave me an email before that, but Attorney Tipton, what do you think about that first shot?
If I may.
Attorney Porges.
So I had a brief discussion with the Commonwealth this morning, and my understanding is that they're filing a request to impound the protective order in which they would show it to the court, show it to us.
They did.
Okay.
Did
we
you
have-
get that
we
before
have
the
a-
hearing?
We did. So we have the protective order. So our main concern this morning was asking the court to order the Commonwealth to review the material for any exculpatory material or issues. If the court's inclined to do that, then I don't need to be heard further. I would just highlight that a case came down just yesterday that is decidedly on point with this issue. You're smiling because you know, or you're smiling because you know?
I think I know.
Okay.
I
It's Commonwealth versus Goparian, and I would refer everyone to the section that discusses possession, custody, and control. Furthermore, the new Mass Rules Criminal Procedure do in possession of federal grand jury material that was investigating not only Trooper Proctor, but possibly the integrity of a murder investigation done by this very county, by these very officers. And so I just want to be clear that if the court is going to order it and the government is going to accept the order, that we want to make sure everyone has the same understanding of what exculpatory is. So otherwise, I have nothing further unless the court has any questions.
No, although, let me see if I can get to that paper. So I like to take things very logical person, I like to think anyway. So I like to take things step by step. So we'll just go in that manner and we'll cross each bridge when we need to.
Okay.
But I know two particular parts of the order that got my attention.
But when you say order, do you mean the protective order, or do you mean the motion that Mr. Tipton filed?
The protective order. And one is paragraph 14, which may bring you somewhere else. And I'm doing this I'm putting the high beams on for your future, should we need to. Paragraph 14.
I think that's a bridge we'd have to cross.
Yes, and
At one point.
yes. And the other paragraph that stood out to me as having relevance to this issue is the opening sentence, or all of paragraph 11, with regard to the issue of possession, custody, and control.
The first sentence of paragraph 11?
I think it might be one, yeah, yes. So, but we don't have to,
I don't think
I'm
that,
just alerting you to those two paragraphs because they're two things that caught my attention as we move forward on this issue. But let me hear from the Commonwealth first with regard to
okay.
and then I'll go back to the defense. Thank you, Attorney Porges.
Thank you, Your Honor. So it's kind of a unique posture because my co-counsels are not party to reviewing the protective order at this juncture. So First Assistant Lisa Beatty has been in contact with the Special Assistant.
What does
Attorney General.
supervisor mean?
That would have been the chief of the appellate unit at that time who signed the protective order in 2024. So as
But it says, is that right?
that was the way.
Hold
they
on a
were-
second. I just want to go back and see what the. So I refer you to 6B. What does that mean?
when that was drafted, it was relative to supervisors assigned as part of the Karen Reed prosecution.
Right,
So at that time, it was the first assistant, Lynn Beeland.
but it wasn't just appellate supervisors. It says
Correct.
any
Correct.
supervisors of counsel of record. So anybody that was counsel of record supervisor, which could be multiple levels. I don't really know, haven't studied your corporate structure.
Correct, but as I can say today, well, defense counsel has the opportunity to review the protective order. My co-counsels have not had that opportunity. So Lisa Beatty is in contact with the Special Assistant Attorney General, who has an update. She's on Zoom, if your honor would like to hear from her, where the office is working with the U.S. Attorney's Office about any future amendments to this protective order or any additional clarification that the office is seeking about any potential further disclosure. So if you would like to hear from her, she is on Zoom and could fill the court in on, recent updates that occurred this morning.
Yes, please. Welcome, ADAB. I can't hear you. Hold on. Can we try that again?
Can you hear me now?
Yes, I can, thank you. I can't see you anymore, but I can hear you.
Can you hear me now, Your Honor?
Yes, and I can see you.
Okay, great, thank you. Your Honor, I'm in the process of drafting my notice for Judge Kruk, which is due in 18 minutes. And I got a call from our counsel informing us that at this time we will be able to view the protective order. I know that not all assistant DAs in the office have been able, and I have not been able to view the protective order until I just learned this information. So I can't speak to what's in the order. So that will be able to be changed if there are ADAs who have matters that are in the posture that we are providing discovery and need to address these issues. ADAs will be able to look at the order. In addition, defense counsel, after the state court and defense counsel have signed a protective order, defense counsel will be able to have a copy of the July 21st order as well as the December 2nd protective order. Those are sort of my updates as I'm receiving them now. And then the U.S. Attorney's Office has acknowledged that we need additional accommodations or modifications. I don't know the exact words that they would use, but we have additional requests in order to be able to move forward with cases in a productive manner. And they understand that we're going to continue to engage in dialogue with them and possibly the federal court about how to manage these situations.
All right, thank you for the update.
Now, just add, the case that came down yesterday is distinguishable because in that matter, the SJC said that the DA's office did not have those materials, that federal materials in, perhaps a protective order remain in the custody of the federal government. That case is distinguishable because a Worcester police officer participated in the interview and had personal knowledge that he could have discussed or disclosed to the ADA, that the ADA did not pursue that information that would have been held by a Worcester police officer. It is distinguishable that pursuant to this order, that materials do remain in the care, custody, and control of the federal government, and the DA's office is just prohibited from any further disclosures.
So what of my suggestion with regard to your role?
That is a role I understand. That is a role I can represent to the court in a different matter. Upon my review of the materials, I saw a statement that was clearly exculpatory in a different case. I spoke to the U.S. Attorney's Office about that matter and had to advise defense counsel and trial prosecutor in the office that they needed to seek a two-week request. I could not disclose that directly. The U.S. Attorney's Office did not produce that outside the protective order. defense counsel and the Commonwealth had to seek that information. I provided date stamps, numbers to counsel, and they had to go to the U.S. Attorney's Office.
But I'm suggesting that in this case, you do that first step.
And that, I would say, has been done, and it's sort of in the similar posture where we represented to counsel that you need to file 2 requests. Counsel filed the 2 requests, the Commonwealth filed its own 2 requests. The U.S. Attorney's Office denied that.
But the difference is, in the other case, you identified a document that you believed. What I'm asking the Commonwealth to do, and I'm asking you to do it now in light of the new rules of discovery, not the ones that may have applied when you did it the last time,
Yes,
is
Your
to
Honor.
review those materials and identify whether we even have something to worry about.
And the understanding would be trying to, without knowing the defense theory of the case and seeking the broadest, what is most
That's
favorable to
always
the
the
defendant.
burden. That's always your problem. I don't mean you. It's always the prosecution. That's, I mean, they make that argument, I don't know, a couple times a week before me when I'm sitting in a criminal session. They can't possibly do as good of a job as me. And yet you have to. That's what the rules require.
And I understand my obligations as a prosecutor to do that. It just becomes a difficult conundrum where if there was a matter, I cannot disclose it to defense counsel, and I cannot disclose it to the court.
I
due to the
understand that.
restraints of the order.
I understand that, but why is it not, I don't want to say an easy first solution. It puts a huge burden on you. I don't know how much materials there are in there. But why isn't it the first step that we should be taking here is we have somebody assigned to this case that has access to those materials by virtue of the fact that you were assigned to the Reed case. And you have knowledge of this case by virtue of your affiliation with the case and your prior stuff that I said. Why isn't the easy first step for everybody other than you in the courtroom who has to do the man hours, for you to make that analysis and at an initial matter say there is or is not something in the materials that we need to disclose?
And I can represent to the court that the materials that were produced are related to the investigation of the death of John O'Keefe and not any materials related to the investigation of the death of Anna Walsh.
All right, well, I appreciate that. That falls short of what I'm asking you to do, which is to avert to me, probably by affidavit, that there is or there is not information in. I understand their focus was on there. That doesn't mean that something doesn't make its way in
Exactly.
to that file and those records. And I want some assurance that somebody has laid eyes on those documents and recognizing that it might be unlikely that there's anything to do with this defendant in those records. Close that door.
And to do so, Your Honor, I believe we would have to seek guidance from the U.S. Attorney's Office to make sure it's not outside the confines of the protective order. Because the way the protective order says,
Well, the
you know,
order
summaries
allows you
and
to
things like
review it,
that.
right? The order allows you to review those materials.
for use in the state court action against Karen Reed.
So have you sought guidance from the court with regard to, for review in connection with any other cases?
I believe that is what ADAPD has represented with, where the Commonwealth can't represent itself in federal court, a assistant attorney general has been appointed, and I believe there is ongoing discussions.
Headed to another meeting on this, probably next week, because I don't want this to, I'm not gonna put this out till the 30th, the 30 days, and we're in another fire drill. So we'll talk about that.
Your Honor, just briefly, I'm certainly sympathetic to the position that ADA McLaughlin finds herself in. It's clear that she understands her obligations under Rule 14, under Brady, but I do disagree with her analysis of Goparian. When it talks about reviewing material, the detective in Worcester was a detective on the homicide case in Goparian. And so just for a picture, ADA McLaughlin is an ADA, part of the prosecution team in this matter. The cop in Goparian randomly happened to be present for a proffer on an unrelated case in which someone made a statement. So Goparian went on to specifically state that the law demands at the very least that the prosecutors ask other members of the prosecution team whether exculpatory information exists. So to me, that combined with Brady and combined with Goparian impose a duty for her to look. I understand that she is, and I agree, the 2 paragraphs on the protective order, I think, are very clear. But I don't think it's an automatic, just automatically resolves her or the rest of the team to just not look because they can't. So I think it's a long way of me saying we might have to end up litigating something in federal court. And so I think we do need to kind of figure if the motion, the protective order can be expanded insofar as ADA McLaughlin has to do a specific review for this case, guided by the revised Mass Rules of Criminal Procedure, Section 14, that gives a very clear description of what in fact is considered exculpatory.
Your Honor, may I be heard briefly? I apologize for interrupting. These are exactly the issues that we are in communication with the U.S. Attorney's Office, and I can promise the court that I can address this specific case and this specific request that this court is making at this time when I speak with them.
All right.
If you would give us some additional time.
I will, and I appreciate you specifically raising this because I think we have, I don't want to get, particularly in light of the schedule in this case, I don't want to get dragged down with the other cases that are not in a similar posture. The unique situation here is that ADA McLaughlin has already seen the materials. It's not disclosure to any, she saw them in connection with another task, but it's not like a new person is coming on or a new set of people are coming on at this moment. So that might give us a swifter direction to a better result. So I'll give you some time to see if we can sort that out.
Thank you very much.
All right. So those are the motions that we had here. We're going to set a status on this last issue for next week. Clerk, what do we have?
Judges, we're picking this date. I'm just hoping we can appear by Zoom. Mr. Porges is going to be, Attorney Porges is going to be on trial, and I'm on vacation, but I'm glad to appear by Zoom.
Yes. You're welcome here, and you're welcome to appear by Zoom.
Thank you.
So, now, Clerk, what is our next week look like? Okay.
Radner, if you're willing to, I'm sorry, Madam Clerk, if everyone's available for 2 or 3 p.m., I might be able to get permission just to hop on at 4.
Okay.
But if I might not, I'm just throwing it out there.
Is 2 or 3 p.m. better?
Well, I don't want everyone to schedule around me. I mean, I do, but I could be in the middle of a witness and the judge is like, I can't let you.
Right.
But it's just, there's a higher likelihood.
Well, why don't we schedule it at 2, knowing that probably somebody could, I don't know who you're before, but they might be able to say, take another 10 minutes.
And he's lovely, I'm sure he would, I just don't know where we're gonna be.
So Friday the 1st?
No, any day but Friday.
Oh, any day but Friday, sorry, I apologize. The 31st, is that available?
We can do Friday the 1st.
Oh,
Whatever works for the court.
So why don't we do Friday the 1st at 2 p.m.?
Friday the 1st at 2 p.m.
Okay, Friday the 1st it is, 2 p.m.
Madam Clerk, to issue a Zoom in to Norfolk for Mr. Walsh.
Yes, I'll request it through the Norfolk County Clerk.
Thank you. Oh, I'm sorry, I can do that too.
That's all right.
Email.
We'll be in contact with them.
Thank you.
The motion to dismiss is under advisement. The matter is continued to August 1st at 2 p.m. here at Plymouth Superior Court. A Zoom meeting will issue for Mr. Walsh. All parties may be present.
They may.
All right, thank you.
Thank you, Ron.
everyone.
Thank you,
Have a
Madam
good
Clerk.
day.
What, all rise.
All right.
Goodbye.
Bye. All right. Well, that last part was really, really interesting. Okay, so what that last part was more interesting than probably the first part. First part really was interesting also, just on a different level. And that was that he was making an argument about the grand jury. And the grand jury came down with an indictment for Brian Walshe. First-degree murder. Now, first-degree murder is generally defined with murder with malice aforethought, which means that you have malice. There's premeditation. If you can show to the grand jury that there's premeditation, well, then you can, and there's probable cause. Again, it's a very low burden. Then the person can be indicted on premeditation. But malice is different than, I shouldn't say malice, but premeditation, when you can prove premeditation is one thing. The second thing is if you can prove extreme atrocity and cruelty. They're two different theories. There's premeditation, and then if you can show that this person carried out this murder with extreme atrocity and cruelty, that also suffices for first-degree murder. So they're two separate theories, but they still work within the confines of a first-degree murder charge. What the defense here was trying to do was saying that there was sufficient evidence he's probably arguing this also, but even if we were to assume that there is sufficient evidence, even at the grand jury stage, to show premeditation, where again, the reasonable inferences can be made in the prosecution's favor. So if you can, can ignore all the exculpatory evidence, you're allowed to do that, right? So if you can prove premeditation, that's one thing. But if you cannot prove extreme atrocity and cruelty, well, then that theory should be out. Now, what the judge was saying is that you are dressing, this is really getting more technical, you're dressing this up as a motion to dismiss that part of the indictment. What the judge was saying is that you're not really dressing this motion up properly. This should be a motion in limine. A motion in limine filed before the court saying that when we go to trial, the prosecution cannot present this theory. They cannot present this theory of extreme atrocity and cruelty if they don't have sufficient evidence for that. They cannot argue that to the jury. That's really what a lot of the conversation was around with respect to the first motion. So again, the defense dressed it up as a motion to dismiss, and the judge was really fighting back, saying, look, the indictment is first-degree murder. Do you have any issue with that first-degree murder on the premeditation part? You're not really, right? They have enough sufficient evidence for that, at least. But then when it gets into the extreme atrocity and cruelty, what about, okay, we can kind of hear an argument there, but who cares? It's just two different theories within the first-degree murder charge. So that's really where they were arguing a little bit back and forth. And it's really just a question of, whether this should be addressed now in a motion to dismiss or a motion in limine. And what the judge was saying kind of is, look, we're getting close to trial. Our trial's in October. We're getting close to that trial date. You, as a prosecution, as a Commonwealth, you got to figure out your theory at this point, right? So and the judge basically said that everybody in the courtroom understands that the theory of extreme atrocity and cruelty is not you don't have such great evidence for that. Now, yeah, you got some Google searches and stuff like that, we can discuss, but the argument here for extreme atrocity and cruelty is not the greatest argument, whereas opposed to the premeditation part, you have much more evidence. So she was kind of hinting to the prosecution, if I had to try this case, I would probably try it as a premeditation case with malice. There's three different prongs of malice, but let's not get into the details right now. Proving premeditation as opposed to trying to convince the jury that this murder was committed with extreme atrocity and cruelty. And she was kind of like hinting that to the prosecution and saying, this can all be just a question of semantics at this point. Like, what are we going to, whether it is a first degree charge, whether it's not, and, whether it's a theory that's going to work and not going to work. Just figure out what your theory is and then let's move on. Like, that's essentially what she was saying. And she was also kind of hinting to the prosecution, I think you probably have a better chance of just plain premeditation. The second part is a little bit more interesting. The second part has to do with the federal materials that were turned over in the Karen Reed case. So they want, the Brian Walshe defense team wants some of those materials, especially as it relates to specific detectives and policemen that were involved, or troopers that were involved in the Brian Walshe case, just like they were involved in the Karen Reed case. So Buchanan, for example, right? Proctor. So this is where the defense is saying, look, they have a Rule 14, and you guys all know about Rule 14 at this point. As a prosecutor, and they just amended the rules to expand it even more, that when you're a prosecutor, you have certain evidence, certain exculpatory evidence, you need to turn that over to the defense. Now, the question always is, well, what is the scope? What's considered exculpatory evidence? Is it just clear evidence? What about if it attacks the credibility of one of the testifying officers or troopers? Then that would also be included. So part of what the argument was is that there was a case that just recently came down, I don't know, maybe days ago in Massachusetts from the SJC, the Supreme Judicial Court in Massachusetts. This case came down, and the case said that basically she didn't say what it said, but it really expanded the scope of what's considered exculpatory evidence, which would then mean that that's part of Rule 14. And therefore, what they're saying is that since A.D.A. McLaughlin is involved in this case, she knows everything about those federal materials from her review in the Karen Reed case. She should also do a review and for the Brian Walshe case and see what is considered relevant and what is considered exculpatory. And therefore, should have to turn those things over. Now, here's the issue. The issue is that there's a protective order. There's a protective order that was signed into by the Commonwealth, by the prosecution, probably the defense also. We never saw this protective order. They're talking about it in code. We don't know what it says. But what it basically says, from what we did get from it, is that the protective order says that the prosecution can review the federal materials as it relates to the Karen Reed case, their prosecution. So what McLaughlin was arguing is that I am not even allowed to do an independent review of the federal materials as it relates to Brian Walshe's case. I can't even do that because the judge was saying, look, we understand that there's protective order here. We understand that maybe you're not allowed to even turn over these materials unless you get authority from the U.S. Attorney's Office. But what you could do is look through the materials. You have them. So look through them. If you can identify any of the materials that need to be turned over as part of your Rule 14 obligations, well, then just let me know about it. And then we'll deal with it then. We'll deal with, you say, okay, I found these sort of documents that, or this sort of evidence that potentially could be exculpatory. And in a regular case, I would turn these things over. But because of the protective order and because of everything going on with the federal case, and everything has to go through the U.S. Attorney's Office, maybe I cannot turn these documents over. But at least do the review, see if there's something there, and then let the court know about it. Well, that is what McLaughlin said, that no, I can't even do that because the protective order says I am only allowed to review those materials as it relates to the Karen Reed prosecution. And that's why we're right now at a standstill, where the judge said, okay, we're going to have to take this up in another week because I forgot who was it Lynn Beeland that was on the Zoom? I forgot who was on the Zoom, but there was somebody else on the Zoom who said, I have to go back to see who it was, but said that they're going to be working this issue directly out with the U.S. Attorney's Office right now. So in another week, they'll have an answer whether they're able to expand the scope, I guess, of the protective order to at least allow a review of the materials and then see how it relates to the Brian Walshe case and then maybe turn those over as part of the exculpatory evidence and part of the Rule 14 obligations. So that is what's still outstanding. And again, she did not make a ruling on the motion to dismiss. It doesn't seem like it's a very novel ask. That's what the judge is saying, that this has never happened before. We're, again, going back to the first motion that was filed, to just dismiss a theory of the case. You talk about dismissing charges. You could talk about, dismissal of the case. You don't talk about generally, a dismissal of a theory of a case. And really she said that's more for a motion in limine, which you could be filing. So most likely I see that the way that that's going to be coming down as not dismissing the theory. And then if they want to file a motion in limine, she'll deal with it then. Now, there is still outstanding this whole motion to suppress issue. I did not see any sort of order on the motion to suppress. And that comes back to the Google searches. The Google searches where, for example, these are some of the Google searches that were done on Brian Walshe's devices. Best state to divorce for a man. How long before a body starts to smell? How to stop a body from decomposing. How to embalm a body. 10 ways to dispose of a dead body if you really need to. How long for someone to be missing for inheritance? Cohasset dump, Hingham dump. Can you throw away body parts? What does formaldehyde do? How long does DNA last? So there were some very incriminating Google searches that were done, and that was the subject of this evidentiary hearing, which happened just recently. It was a week or two ago, and also the basis of a motion to suppress that all of these Google searches were taken from devices where there was no search warrant that was performed when they did these searches. And these are searches that were done by guess who? Michael. I'm not searches, but the download of these devices, and these searches were found by a former trooper named Michael Proctor. And the argument by the prosecution was that this was all with consent. We discussed this at a previous video. We analyzed some of the evidentiary hearing parts, but that's a very important part of this case, obviously. If these Google searches get suppressed, Brian Walsh's chances of getting an acquittal rise significantly. If these Google searches get admitted into evidence, he doesn't stand much of a chance, I think. So very significant, these Google searches. And if they did not have the proper consent, if it wasn't documented correctly, as we spoke about in our previous videos on this, if they're not able to get them in through the inevitable discovery doctrine, well, then that's going to be a real issue for the Commonwealth trying this case. Yeah, fruit of the poisonous tree, exactly. So that's what we're still waiting on in terms of that. Here's the question from Nikki. What's the hierarchy? Rule 14 of the protective order. I would say the protective order. If the federal government gives you materials and requires you to sign a document that says that you're not going to turn them over and you're not going to review them even outside of the scope of the Karen Reed case, they would be stuck with that protective order. They're going to have to work this out. It's not going to come down to that. They're going to have to work this out with the U.S. Attorney's Office. And I think they're eventually going to be able to review the materials. So, yeah. All right. Well, that was the hearing today. We'll probably have to do a recap on this because there's a lot of code here because we weren't able to see the motion because all the grand jury is impounded. The motion was impounded. The memos were impounded. They were talking about some case, which we never saw because that was impounded. Everything is impounded when in respect to the grand jury testimony. They're talking about these people in code. And that's why it's some of the things remain behind closed doors and we're not able to really get a full look at it. So I'm going to watch it again carefully, try to pull out as much as I can, read between the lines, and hopefully we'll do a recap on everything going on, what just happened in the Brian Walshe case. So thank you all for joining me today. I'm glad we got the stream. Thanks to NBC 10 Boston. My buddies over there appreciate that stream and able to get it and not have to look in through the Zoom, which is not as clear of a picture. So we were able to do that. And yeah, so look out for the video later. There's a few other things that are going on now, by the way, just so you should all know. There's a bunch of motions in limine that were filed in the Adelson case, Donna Adelson case. Definitely like to do that. I'm sure a lot of you heard about the sentencing yesterday in Brian Koberger's case. And there's also a new case that I'm looking into. There's a new case that I'm looking into, which sounds very, very interesting. And I've been sent some materials by people close with the case. It seems like it's gotten some publicity, but not a lot. I think most of the law tours have not been covering this case yet, but I'm really thinking about covering this case because it's very, very interesting. Let me give you a little idea. It's the case Mahendra Patel. This has to do with an attempted kidnapping charge, and he's being represented by Ashley Merchant. who is a very respected criminal defense attorney. And it seems like the evidence on this case, from what I've seen so far, is really lacking. They may have overcharged this person or unfairly charged this person. So I'm really looking into that case. I'm going through some of those materials, and we'll see. Maybe that's actually the trial's coming up very soon, also in August. So that may be something we're going to be covering as well. So there's definitely a lot to cover. There's a lot to go through. Thank you very much for joining. Thank you to Truth for Liberty for that. Thank you for the review. Appreciate that. And yeah, so we're going to keep everybody busy. I'm definitely going to be very busy. I have a trial of my own coming up, I think in September time. So we'll see what happens with that trial. Hopefully it'll be a quick trial, but that's what I have going on in my plate. So we'll see you all next. Oh, look at that. We have somebody who knows about the case. Jessica, Pinky Mingo. Oh, that Patel case is absolutely infuriating. The accuser belongs in jail. Yeah, there's some very interesting things about the accuser. I'm really wrapping my head around it now, but like I like to read everything and make sure that I'm all caught up before I start hurling, allegations and things like that. But I've seen the video of that case where the person's in Walmart, where he's being charged with attempted kidnapping. And it's really, really not clear at all what he's trying to do there. It does not look like he's trying to just grab a kid and run, to say the least. So, okay, Jessica lives in Georgia. We have some Jessicas that live in Georgia. There's another Jessica that lives in Georgia. But yeah, so I'm looking into that case. All right, well, that's going to be it for now. Thank you all for joining, and check out the recap video, hopefully coming out later this afternoon as well. And we will see you next time.